Thank you for joining this overview presentation of the Nouveau-Brunswick Residential Tenancies Tribunal. The agenda contains 6 topics that will be discussed: the role of the Residential Tenancies Officer, obligations of landlords and tenants, security deposits and leases, notices and evictions, the 5 steps to solving any issues, and additional resources. The Residential Tenancies Tribunal is an administrative tribunal, and our role is to enforce the Nouveau-Brunswick Residential Tenancies Act. The Residential Tenancies Tribunal does not advocate for either tenants or landlords. We are an unbiased, third-party entity to help an applicant on issues relating to the law. Some of our services may involve investigating complaints, providing mediation services, administering tenants' security deposits, and adjudicating any disputes. The landlord has an obligation to keep the premise and chattels clean, in working order, and fit to live in. Chattels is a term used to define a landlord's or tenant's personal belongings. For example, if appliances or furniture are included in a rental property, those would be considered the landlord's chattels. Personal belongings brought into the premise by a tenant are considered the tenant's chattels. The landlord must comply with all health, safety, housing, and building standards and any other legal requirement. The landlord must also ensure all common areas are clean and safe. First and foremost, a tenant must pay their rent on time. Tenants must keep their place clean. Tenants must repair any damage caused by willful or negligent conduct of the tenant or the tenant's guest. Tenants must avoid causing any disturbances or being a nuisance. Landlords do not have to request a security deposit, nor do they have to get a lease signed. However, if a tenant provides a landlord with money in exchange to live at the premise, the tenancy is still covered by the Residential Tenancies Act. If a lease is signed, it is very important to read the details of the lease. There is information related to when a lease starts, ends, gets renewed, and what services are provided within the agreement. If a security deposit is collected, by law it must be remitted to the government within the first 15 days. The tenant can remit the security deposit to any Service New Brunswick Center, or the landlord may remit it on behalf of the tenant. When a security deposit is remitted to the government, it creates a tenancy between the tenant and landlord. Both landlord and tenant receive a confirmation that a security deposit has been received and are provided with a tenancy number. It is important to retain this number for any future correspondence with the Residential Tenancies Tribunal. The security deposit is owned by the tenant, and the Residential Tenancies Tribunal holds it in trust. However, at the end of a tenancy, a landlord may submit a claim against a portion or the entirety of the security deposit. Some common reasons for a claim would be repairs, cleaning, or unpaid rent. Landlords do not evict tenants. Only a residential tenancies officer can evict. If rent is not provided on or before the day it is due, a landlord can serve a tenant with a notice to vacate the day after the rent is due. The tenant then has 7 days to pay the rent in full, or will have to vacate the premises within 15 days. If a tenant does not vacate the premise, at that point a residential tenancies officer can issue an eviction order and have a sheriff remove the tenant, allowing the landlord to regain possession of the premise. A notice of termination is served when either party decides to end a tenancy. In a month-to-month tenancy, a tenant would have to give at least 1 calendar month's notice to their landlord that they are not going to renew their lease. No reason is needed. The same goes for the landlord. They can provide the tenant with a month's notice to end the tenancy, and no reason is needed. The notice of termination has to be in writing, be dated, be signed, indicate the premise, and the person to who it is addressed. In a year-to-year tenancy, the notice of termination has to be served at a minimum 3 calendar months prior to the end of the tenancy. Please note that 3 months notice is prior to the end of the tenancy and not 3 months at any time during the tenancy. If a notice is not served, the year-to-year lease automatically renews for a new year. The Residential Tenancies Tribunal can review a notice of termination if it is in question. 5 steps to resolving any issues. These 5 steps apply equally to both tenants and landlords. Given the target audience here are tenants, I will speak in terms of how a tenant would approach a situation with their landlord. First step is to have a discussion with your landlord. If the landlord does not address the issues raised by you, the second step is to put in writing the issues and ensure it is dated, signed, indicates the premise, addressed to the landlord, highlighting the issues you would like addressed, and has a time frame, usually 1 week, to address issues. When you serve your landlord with this letter, please keep a copy for yourself as well. If the issues raised are still not addressed, then you may go to step 3. At step 3, you can apply to the Residential Tenancies Tribunal for assistance. Please note that the Residential Tenancies Tribunal will be asking for a copy of the letter you served your landlord in step 2. Depending on the details of the case, mediation may be attempted. If mediation is unsuccessful, adjudication may occur. The Residential Tenancies Officer's decision can be appealed at the Court of Queen's Bench only if there is an error in law or that the Residential Tenancies Officer did not have jurisdiction. Additional information is available on the Residential Tenancies Tribunal website at www.snb.ca/irent. Email inquiries can be sent to irent@snb.ca. Telephone calls can be answered by calling our toll-free number at 1-888-762-8600.